This video will discuss what happens after a UK spouse or partner visa is granted, what the applicant can and cannot do, and important considerations for future applications. As an OISC regulated UK immigration law firm that has helped more than 4,600 partners obtain their UK partner visas, we're very well placed to discuss this. This video is split into 4 sections. We will discuss 1. When an out-of-country application as a married, civil or unmarried partner has been granted. 2. When an out-of-country fiancé or proposed civil partnership visa application has been granted. 3. When an in-country application as a married, civil or unmarried partner has been granted. And finally, 4. We will address the question, how many days can the applicant spend outside the UK whilst having a UK partner visa? One of the most common questions in our YouTube comments box is whether the application was or will be an out-of-country or in-country application, so we will quickly discuss that now. If the applicant, who's the person who needs a visa to enter and live in the UK, does not have any UK visa or leave, an out-of-country application will need to be submitted. This is the case even if the sponsor, the UK partner, helps complete and submit the online application and if they help submit the supporting documentation. To make an application from inside the UK, the applicant must 1. Be in the UK when the application is submitted, 2. Must not be in the UK as a visitor, and 3. Must be in the UK with a valid visa or leave granted for a period of 6 months or less, unless they're in the UK on a fiancé or proposed civil partnership visa. We'll start with out-of-country applications as a married, civil or unmarried partner. Once the application has been decided, applicants will normally receive an email. This is sometimes sent to an email spam or junk folder, particularly with Outlook, Hotmail or Live accounts. If the applicant attended a VFS visa centre, the email will look something like this. If the applicant attended a TLS visa centre, 2 emails are normally sent out. The first email normally states that a decision has been made. The contents of the second email, like the first, varies considerably, but here's an example. Regardless of whether the applicant attended a TLS or VFS visa centre, if you did not opt for the courier service, the passport must be collected from the visa centre. If you opted for the courier service, they would then post the passport to the specified address provided during the online application process. If you opted for the Keep My Passport service and received an email requesting that the passport be returned, congratulations. This is only requested if the application is successful. They will not request the return of the passport, only to say that the application was refused. Once the passport has been returned, it will normally be at this stage once you find out whether the application has been granted or not. So open the passport and look for the 90-day entry clearance vignette inside the passport. This is like a visa sticker and looks like this. In this example, you can see that it says standard. If the vignette includes the phrase standard, the application was granted on the 5-year route to indefinite leave to remain, which is standard. If it states non-standard, the application has been granted on the 10-year route to indefinite leave to remain. If you find that there's been an error on the vignette, the Home Office guidance states that you should contact your visa application centre immediately to correct it before coming to the UK. It then goes on to state that if you notice the error after you've arrived in the UK, you must report it to UK Visas and Immigration within 3 months of arriving, or you'll be required to make a new application. If you contact the Visa Application Centre before the applicant comes to the UK, please note that this would normally require the passport to be handed over at the Visa Centre, and then you'll need to wait for them to reprint the vignette. Because of this, partners tend to enter the UK first and then report it, due to the practical complications of waiting for the vignette to be reprinted. This 90-day entry clearance vignette is not the UK partner visa. Rather, it's just a visa that should be used to enter the UK. The actual partner visa is usually granted for 33 months. The start and end dates are normally found on the decision letter. When should I travel to the UK after the visa is granted? The applicant will be expected to travel to the UK during the validity of the 90-day visa. Entering the UK at any point during the validity of this 90-day visa is fine, even on the last valid date. Entering later rather than earlier is not something that would normally cause issues with regards to the extension application and the subsequent indefinite leave to remain application. The immigration rules state that the applicant must either be joining or accompanying their sponsor in the UK. So if the sponsor is already based in the UK, the applicant can enter the UK alone. If the sponsor is based overseas when the application is submitted, the sponsor should enter the UK at the same time as the applicant. So if the sponsor is based overseas with the applicant and has some ties to finish, to avoid complications, they would normally be advised to enter the UK with the applicant and then return overseas to finish those obligations. Alternatively, partners delay the date at which both enter the UK. Please note that if the applicant does not travel to the UK during the validity of the 90 days, you'll need to apply and pay for a replacement 90-day visa. More information about this can be found by visiting www.gov.uk/transfer-visa. When the applicant arrives at the airport, they will need to bring the passport that has the 90-day entry clearance visa. If a TB test was required in the first place, the TB test certificate is expected to be brought with them, but these are very rarely requested, and it will not be an issue if the TB test has expired on entry to the UK. The applicant will not be expected to have booked a return flight. We do not generally recommend the applicant go through the electronic gate at the UK airport. Rather, the applicant should speak with an immigration officer to determine whether the vignette needs to be stamped. Let's now discuss when the applicant has arrived in the UK on a UK spouse or partner visa. Once in the UK, the applicant can work in the UK, including paid and unpaid employment, can take part in paid and unpaid work placements as part of a course or period of study, can be self-employed and engage in business or any professional activity. Since payment of the IHS was made, they can also use the UK's National Health Service, the NHS, which provides a wide range of healthcare services, including general practitioner visits, hospital treatments, emergency services, and mental health services. The spouse visa also permits the applicant to study in the UK, subject to the condition regarding the Academic Technology Approval Scheme, which requires an ATAS clearance certificate for the intended course of study. The partner visa is normally issued on the condition that there's no recourse to public funds. Public funds are defined in paragraph 6 of the immigration rules as the following. Feel free to pause the video to read from the rather long list of public funds. National insurance numbers are not automatically issued. Rather, the applicant must make a separate application to the Department for Work and Pensions to obtain one. More information about this can be found by visiting www.gov.uk/national-insurance. And finally, it may be worth noting that in the application, you would have stated that you'll be living at a certain address. If for whatever reason you decided not to live at that address, this is not something that you need to inform the Home Office about. The UK is currently transitioning from BRPs to e-visas. Until the UK is transitioned to e-visas, applicants will be expected to collect the BRP from the designated post office that was selected as part of the online application process. The decision letter issued to applicants provides more information about this. Preparing for the next application. So the 33-month partner visa can be extended for a further 30 months by submitting the FLRM application form. When the time comes to submit the FLRM application form, you'll once again be required to show that you've satisfied the requirements. We discussed the requirements and the FLRM application process on our website www.migrate.org.uk. The relevant date that you must show that the requirements are met is the date that the FLRM application is submitted, and this is the same date the Home Office application fee on the online application form is paid. So you will not need to satisfy the financial requirement throughout the duration of the partner visa. Therefore, if you use cash savings or employment income to satisfy the financial requirement for the partner visa, it's fine for you to spend that cash savings or for the employed person to quit their job if the financial requirement will be met when the next application is submitted. We have a separate video which discusses when the application should be submitted. In short, in most cases, applicants should submit the FLRM application within the 28-day period before the partner visa expires. We discuss how much time you can spend outside the UK closer to the end of this video, so feel free to check out the YouTube timestamps to skip to that part. Out of country fiancé visa or proposed civil partnership visa applications. Applicants normally receive an email once the fiancé visa application has been processed. This is commonly received in the junk or spam folder, so you may find it there. If the applicant attended a VFS visa centre, the email will look something like this. If the applicant attended a TLS visa centre, 2 emails are normally sent out. The first email normally states that a decision has been made. The contents of the second email, like the first, varies considerably, but here's an example. Regardless of whether the applicant attended a TLS or VFS visa centre, If you did not opt for the courier service, the passport must be collected from the visa centre. If you opted for the courier service, they would then post the passport to the specified address provided as part of the online application process. If you opted for the Keep My Passport service and received an email requesting for the passport to be returned, congratulations, as this is only requested if the fiancé visa application is successful. They will not request the return of the passport, only to say that the application was refused. Once the passport has been returned, you should see a 6-month vignette, which is like a visa sticker in the passport. Unlike UK partner visa applications as a married, civil or unmarried partner, and assuming the fiancé visa is granted, you will not receive a decision letter. These are only issued if the fiancé visa is refused. The vignette should also state something like no work or recourse to public funds. Public funds are defined in paragraph 6 of the immigration rules to include the following. Feel free to pause the video to read these. Entry to the UK can be made any time during the 6-month validity period. However, because the applicant will be expected to give notice at the local registry office, marry and then prepare and submit the subsequent spouse visa application, applicants should normally enter the UK sooner rather than later. Generally speaking, entering the first 2 to 3 months tends to give partners enough time. If the applicant enters after this, unexpected delays with giving notice, getting married, or general life events can make the timeline uncomfortably tight. The immigration rules state that the applicant must either be joining or accompanying their sponsor in the UK. So, if the sponsor is already based in the UK, the applicant can enter the UK alone. If the sponsor is based overseas when the application is submitted, the sponsor should enter the UK at the same time as the applicant. At the UK airport, we do not generally recommend that the applicant goes through the electronic gates. Rather, the applicant should speak with an immigration officer to see if the fiancé visa needs to be stamped. When the applicant arrives at the airport, they will need to bring the passport that has the 6-month fiancé visa. If a TB test was required in the first place, the TB test certificate is expected to be brought with them, but these are very rarely requested, and it will not be an issue if the TB test has expired on entry to the UK. The applicant will not be expected to have booked a return flight. Once the applicant has arrived in the UK, they should shortly after give notice to marry. 2 sources of information are particularly helpful here. Firstly, this gov.uk webpage, which can be found by googling Notice of Marriage gov.uk, and this Citizens Advice webpage, which can be found by googling Getting Married Citizens Advice. However, on the topic of leaving enough time to get married in the UK, it's worth quickly pointing out 2 things on the gov.uk page. Firstly, to give notice at the local register office, you must have lived in the registration district for the past 7 days, and you must give notice at least 29 days before your ceremony. You'll likely read about a potential 70-day notice period, rather than the standard 28-day period. The 70-day notice period is very unlikely to apply to those in the UK on a fiancé or proposed civil partnership visa. If, for whatever reason, you cannot marry during the 6-month period, there is a provision in the immigration rules which states that applicants can apply for a 6-month fiancé visa extension if there is a good reason why it did not take place and you're able to provide evidence that it will take place within the next 6 months. However, making this application is rather costly and time-consuming and is best avoided. Preparing for the next application. So the 6-month fiancé visa can be extended without the applicant leaving the UK by submitting an FLRM application form. The FLRM application form should be submitted after marrying or entering into a civil partnership, but before the expiry of the 6-month fiancé visa. Applying 1 day before the 6-month fiancé visa expires is normally fine, as applying before the expiry date will automatically extend the fiancé visa until the application has been decided or until it's been withdrawn. So most partners find that they do not need to purchase the super priority service. Just like when the fiancé visa application is submitted, you'll once again be required to show that the requirements are satisfied when you submit the FLRM application, including the financial requirement. So, since the fiancé visa is only valid for a short period, it is essential to start planning ahead on how you meet the financial requirement for the FLRM application. We discuss the requirements and the FLRM application process on our website, www.migrate.org.uk. It is ordinarily fine to travel overseas for the honeymoon during the validity of the fiancé visa. However, there are a few things to be aware of. Firstly, to extend the fiancé visa from inside the UK, the applicant will need to re-enter the UK during the validity of the fiancé visa. Secondly, a copy of the marriage or civil partnership certificate should be taken on the trip. And this is because the applicant will need to satisfy the immigration officer of their intention to apply for the in-country spouse visa application on their return to the UK. Finally, if the FLRM application has been submitted and is being processed, the applicant should not leave the UK, as doing so will automatically withdraw the application. In-country applications as a married, civil or unmarried partner. For in-country UK spouse and partner visa applications, the applicant will receive an email once a decision has been made. Since this email is sometimes received in the junk or spam folder, you may have to check there. The email will normally state whether the application has been granted or refused. If the application has been granted, the decision letter will normally state the expiry date of the new leave. And if you're unsure what leave means, consider another word for visa. What applicants can and cannot do. Those granted an in-country spouse visa can work in the UK, including paid and unpaid employment, take part in paid and unpaid work placements as part of a course or study, be self-employed, and engage in business or any professional activity. Since payment of the IHS was made, they can also use the UK's National Health Service, the NHS, which provides a wide range of healthcare services, including general practitioner visits, hospital treatments, emergency services, and mental health services. If the IHS was previously paid as part of the applicant's visa before the spouse visa, and there was an unpaid period because of switching into the spouse visa category, the Home Office should issue a pro rata refund for any unused portion of the IHS previously paid. The in-country spouse visa also permits the applicant to study in the UK, subject to the condition regarding the Academic Technology Approval Scheme. The partner visa is normally issued on the condition that there's no recourse to public funds. Public funds are defined in the immigration rules as the following. Feel free to pause the video to read from the rather long list of public funds. Let's now discuss preparing for the next application. The next application will depend on whether the applicant will be eligible to apply for indefinite leave to remain. Indefinite leave to remain, otherwise known as ILR, can normally be applied for after 5 years. It is generally only where the applicant did not meet certain requirements and there are exceptional circumstances will the applicant be granted a partner visa on the 10-year route. So, this means that for applicants who first applied out of country as a married partner, civil partner, or unmarried partner, this typically involves the first out of country partner visa application, which will be granted for 33 months, the first partner visa extension application via the FLRM application form, which will be valid for a further 30 months. Then, assuming that the first spouse visa application and first spouse visa extension were granted under the 5-year route to ILR, the indefinite leave to remain application. This application is submitted using the Set M application form. For applicants who first applied out of country as a fiancé or proposed civil partner, the route to indefinite leave to remain typically involves the fiancé or proposed civil partnership visa application, which will have been valid for 6 months, the first application as a married or civil partner via the FLRM application form, the first spouse visa extension application, and this application is also submitted via the same FLRM application form, and then the indefinite leave to remain application via the Set M application form. And applicants who first applied for an in-country application as a married partner, civil partner, or unmarried partner typically involves 1. Submitting the first partner visa application via the FLRM application form, the first partner visa extension via the same FLRM application form, and then the indefinite leave to remain application via the Set M application form. It would be best if you familiarise yourself with the requirements before applying for the next application. This is because the date that the requirements must generally be met is the date that the FLRM or SETM application is submitted. We discussed the FLRM requirements in detail on our website, www.migrate.org.uk. We may also start to create indefinite leave to remain related guides and YouTube videos, so if you want to be notified of those, you're welcome to subscribe to our YouTube channel. Since the financial requirement must be met on the date that the next application is submitted, you do not need to continually satisfy the financial requirement throughout the duration of the spouse visa. So if you relied on cash savings to satisfy a recent partner visa application, you can spend all the cash savings. And if you relied on employment income, the employed partner can quit their job. Again, you must ensure that the financial requirement is met when the next application is submitted. This may require you to build up and hold the cash savings for 6 months before submitting the next application, or find new employment several months before submitting the next application. A common question is, how many days can the applicant spend outside the UK on a UK spouse or partner visa? This question arises because, understandably, applicants do not want to have any issues when it comes to extending the spouse visa or applying for indefinite leave to remain, and then for some, British citizenship. Regarding the spouse and partner visa extension and the ILR application, the immigration rules do not specify the number of days the applicant can spend outside the UK. However, as we discussed in our spouse visa requirements YouTube video, there's an intention to live together in the UK requirement. Regarding the intention to live together requirement, if substantial periods of time have been spent outside the UK, this should not be problematic if the reasons for the days of absence are consistent with the intention to live together permanently in the UK requirement. So, for example, a partner spending 9 months outside the UK due to work commitments or family illness are typically good reasons for spending time outside the UK. Due to the Home Office guidance not stating a maximum number of days an applicant can be absent from the UK, there will be a degree of subjectivity when there have been absences. Therefore, if a significant amount of time has been spent outside the UK, particularly for reasons which may suggest that there's no intention to live together in the UK, the application should be handled particularly carefully. We discussed this further in our How Many Days Can the Applicant Spend Outside the UK on a UK Spouse or Partner Visa YouTube video. For applicants who intend to eventually apply for British naturalisation, which is the name of the process for which a foreign national can become a British citizen, please note that there is a specified number of days the applicant can be absent from the UK. This topic comes with many exceptions, but in summary, applicants married to a British citizen must not be absent from the UK for more than 270 days in the 3 years before applying, and must not have been absent from the UK for more than 90 days in the 12 months before applying. Applicants not married to a British citizen must not have been absent from the UK for more than 450 days in the 5 years before applying, and must not have been absent from the UK for more than 90 days in the 12 months before applying. Again, there are many exceptions to this, and we won't elaborate further in this video since this is a huge topic in itself. But if you want more information about this, specifically as it relates to the British citizenship application, this can be found in the Nationality Policy, Naturalisation as a British Citizen by Discretion, Home Office document. We discussed the partner visa requirements and the partner visa process in detail on our website, www.migrate.org.uk. If you want us to continue making videos like this, you can let us know by liking the video, subscribing, or leaving a comment. I hope you found this video helpful.